Hey, so today we're going to tackle the question, now that I'm patent pending, am I protected? Hi, I'm JD Houvener, patent attorney, owner, and founder here at Bold Patents Law Firm. I've helped inventors for over 10 years, acquire almost 500 patents now. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. It's been a pleasure helping inventors all these years and helping answer questions like this. So let's get to this one. You know, your patent pending. This is a really big moment. And absolutely, you should pat yourself on the back. You know, pop the champagne cork. It's a big moment. You've filed your invention with the patent office. And hopefully, right, if you've done your research, if you've thought it through and done it the right way, you're the first one to file. That is the way the system is set up. It's a race. Not necessarily who invents it first, but who files it first. So once you're patent pending, what do you have to do now? Because, right, there's this waiting game. If you file a provisional, you have up to 1 year to convert that into a non-provisional. If you file a non-provisional, well, now you're waiting for the USPTO to do their job, assign the examiner, and then get back to you, right, with a rejection or an acceptance, allowance, I should say. So during this type of pendency, I get asked this a lot. Well, am I protected? Do I have legal protection now that I've filed and am patent pending? And I have to tell them, unfortunately, the answer is no. There's no legal protection. In other words, you're not able to go against an infringer, right? If someone starts making, using, or selling your product, there's no federal-backed, legal enforcement mechanism while your patent is pending. But there are a few things we can do, but unfortunately, there's no right until the patent gets granted. That's when you have the bundle of rights to be the only one to exclude others from making, using, selling, or importing your product in the United States or other countries if you filed overseas. So let's take a look at this concept of what do I have? What can I do now to enforce or get ready or position myself against would-be infringers? The first thing you can do is to properly mark your item. If it's a physical product, this is the easiest example. You need to be able to put in permanent marking, patent pending. Just those two words, nothing magical, no other serial numbers, application numbers, that it's what type of application it is. Just simply put patent pending. And that marking, hopefully permanent, will be on your product in a very visible location so that anyone who buys it or sees the product will be put on notice, actual notice, that your product is pending and you're looking to achieve enforcement rights once it gets granted. Now, later, once your patent gets granted, if you can find or track, rather, anybody or any company that purchased your product, was put on notice by your marking, and later still infringed, you can push in litigation and say they were infringers and they were willful infringement. That could be the road down to additional damages, triple damages in later litigation. So by properly marking your product, your physical product, that's the easiest way to do it. Now, if you have a digital product or service or method, you're going to have to be able to label this on a website, right, on an app, or however you're communicating to your customers about your patent pending product. So at that point of sale, as soon as you launch your product or a service, you want to say that it's patent pending. And it should be really, notorious, very obvious that you have the marking on there. And that is, again, mostly, not necessarily to wow or, sort of impress your client base, although sometimes it does that. It really is to go and hopefully try to thwart anyone who might infringe your product and cool the competition before you actually get your patent rights. Now, the second thing you can do to sort of enforce, right, pseudo-enforce while your patent is pending, if you do see an infringer, a copycat, once you hit the market and you're still pending, then you can talk with your patent attorney and they can begin to draft what's called a notice letter. So written by an attorney, sent directly to, let's say, the owner, founder, individual that's infringing. And it's a letter clearly via, certified letter that you are intending on getting this patent that is pending to issuance. And if they continue to infringe, they will be liable for additional damages, threatening lawsuits in the future, and really just talking about how you're probably going to be developing further portfolios. And they should either work with you, pay you a royalty now, or decide to settle and stop producing the product, or find some way to sort of get to the place where you feel comfortable and happy in terms of your commercialization moving forward. Now, the really silver lining here is that typically those conversations end up really positively for the inventor. For someone else, to some other company, to decide to go to market with your exact invention, that tells you that there's a company willing to expend the effort and time to market your product and build it. And then the big one is that there's likely a consumer demand for your product. It's a really healthy thing, very viable in terms of commercialization, moving your invention into the marketplace. So hope this was helpful at this patent pending stage. This question of what do I do now? How much rights do I have? How do I enforce my patent, even though it's pending and not yet issued? I'm JD Houvener, owner and founder here at Bold Patents Law Firm. I'm happy to answer these questions with you. Feel free, if you want to download below our Inventors Kit. This is a lot of information for a lot of our inventors that get started. It's got great stuff, including my book, the full PDF. It's got our blog link. And then the second and third pages are all your options for patent searching, patent application drafting on page 3. And I've got my patent commercialization, what's called a patent success matrix, to see where your invention might be on that grid and see how bold your invention really is. So have a great day, everybody. Go big, go bold.